My name is Stephen G. Cobb, attorney at law, and you're watching Florida Criminal Law TV as we go through a series of different types of sex offense cases. Now we're going to talk about a type of case which on its surface doesn't sound like a sex offense case, but it usually is. That is felonious use of a communication device, an electronic communication device. Well, on the surface of it, that doesn't sound like a sex crime. Let me explain how it is. Someone takes what's colloquially known as a dick pic and sends it to another person. In my world, usually a law enforcement officer that they're chatting up online. These often come packaged with those traveling to meet a minor for unlawful purposes cases under 847-0135, usually 4A, as we discussed earlier. Well, the communication device issue is one of those creative things that the legislature came up with, and it's also one of those charges where you often find, if you're looking for it and you're careful, a double jeopardy issue by the different charges that are laid out, because it's not uncommon to have traveling to meet a minor with felonious use of a communication device, an electronic communication device, and child pornography. I mean, you usually find those in the same set of charges. Not always, but quite often. And with felonious use of a communication device, you can see how the legislature went out of their way to manufacture a crime. In other words, the crime is already going on, but we're going to make this an extra part of it in order to increase punishment. This is really critical to understand. If you've been following what happened with the Cosby trial and the Me Too movement, you have to understand that culturally, while sex offense cases of all types have been difficult to defend, now we have this increased plethora of different types of charges like felonious use of an electronic communication device in furtherance of a felony. A manufactured charge that on the surface has nothing to do with a sex offense case. The reality is simply this. When it comes to all these types of charges in a post-Cosby retrial world where he was convicted, we can see the impact of the Me Too movement. Number one, you haven't been able to get a fair trial in a sex offense case for a long time. Number two, it's worse now than before the whole Me Too movement. And number three, this makes courtroom psychology more important than ever before. Now at this point you may be thinking, Cobb, I thought you were talking about defenses. Yes, I am. For example, what am I wearing? I'm wearing a suit. Gray suit, white shirt, dark tie, solid color. Now in the courtroom, I normally wear navy or charcoal gray as a suit, long sleeve, white shirt, and quite often a red, white, and blue tie. Why would I do that? What does that have to do with the defense? As a criminal defendant, you should wear and you should do certain things, and you should not wear and not do other things. For example, you probably don't know this, but you get the highest acquittal rate when you have, for example, a male defendant in a navy suit, same white shirt like this one, conservative tie like this one, and no facial hair whatsoever, and not a skinhead look, but short hair, okay? Shorter than mine is fine, longer, long hair, probably not. Why? Because jury selection through running mock trials over and over again has taught us that if you take that white male defendant and you put him in any other color but navy as a suit, if you allow that white male defendant, the testing shows, have any kind of facial hair, you know, oh, I have a real neatly trimmed beard. I've heard this. Oh, my mustache is real neat. Doesn't matter. Don't wear it. I don't care if you've had it for 40 years. Why? Because the conviction rate goes up 28% in testing when they do things like that with different actors with the same set of facts. They make these cases so factually specific and so 50-50, you would never find a case that close in real life. And so with these different types of sex offense cases, including use of a communication device, you want to make sure that your dress is not hurting you. And dressed correctly, it makes an unconscious impact on the prosecutor, the judge, and the jury. Haven't you ever met somebody and you thought to yourself, I really like this person, but you can't put your finger on it? Or have you met somebody and go, ooh, I really don't like that person, and you can't really put your finger on it? It's probably something they said, a behavior mannerism, or their clothing that threw you off, and you don't even know that your mind has been coded that way. Now, more specifically, to use of a two-way communication device, there are a number of different technical defenses that can be mounted where you usually have to hire an expert. It could be someone else used the two-way communication device. That's actually an issue in a case I have right now. Multiple people had access to communication devices that were seized by law enforcement. Now they have a problem. They believe that these communication devices were used to commit a specific type of sex offense, but they cannot identify who was using the device since it was shared by multiple people. Now I want you to imagine that we're having a hearing on, say, an issue related to that under Rule 3.190C4. C1 through 3 don't really matter. They're things that never happen, and I've never seen a motion to dismiss granted because the state violated a double jeopardy issue or that the state violated an immunity agreement, and I've certainly never seen the governor pardon someone before trial. So those three things don't matter. But let's say we have a C4 motion where there's no factual dispute. Being dressed correctly while sitting mute at the defense table, not saying a word, will make a difference. Because if you have facial hair, if you have the wrong color on, whatever you do, do not wear black. Male or female, do not wear black. That is the jail and prison color. Just saying. The numbers are even higher than the 28%. By being dressed correctly while technical defenses are being mounted, where factual defenses such as somebody else was using the device, not me, that's a factual defense. Technical devices, this couldn't have happened that way because technically this particular device has an automatic downloader that surfs the net. It looks like it was a form of malware. It went to porn sites and downloaded improper images. Then it accessed the contacts and started sending them. I mean, those are technical things you have to have an expert go, this is where it's located in memory. This is what it means. They have to break down complex computer technology and explain it to either the judge or the jury, depending on the type of defense, while you're sitting there in the courtroom. And while your family and friends are there, they need to be properly attired for court as well. It's critically important that while these technical defenses to a charge like that, because that's a technical defense charge if ever there was one, it's critically important that you're dressed correctly because that is a key component of your defense, not only this charge, but all types of sexual offenses.